The strategy envisages legislative and institutional changes, as well as changes in practice for the state in order to meet its obligation to respect, protect, fulfill, and promote human rights. In June 2014, the National Human Rights Action Plan for next 2 years was also adopted. It covers concrete activities to be undertaken by responsible agencies, and the Interagency Commission was created, chaired by the Prime Minister of Georgia, to monitor the process of implementation of both documents. Moreover, the government will submit to Parliament the annual report on thematic parameters in March, the same month when it hears the Public Defender of Georgia. The human rights strategy sets the right to participate in social and political life and development of public services, amongst others, as priority. We made significant steps in this direction. In February 2014, the Parliament adopted a new self-government code under which a direct vote and the 50% threshold were introduced first time in Georgia for electing the mayors and gamgebelis. In May 2014, the law of Georgia on elimination of all forms of discrimination was adopted. Elaboration of a new anti-discrimination law was that commenced in 2012 involved all line ministries, local and international organizations. In order to ensure that the best international standards were integrated in this law, the draft law was reviewed by the European Commission Against Racism and Intolerance at the Council of Europe, OSCE Office for Democratic Institutions and Human Rights, and the Office of the High Commissioner for Human Rights. The draft was also examined by the Swedish expert Mr. Hans Ytterberg, selected with the assistance of the EU delegation in Georgia. Most of their feedbacks and recommendations have been reflected in the text of the law. The purpose of the law is to eliminate all forms of discrimination in public and also private sector, and ensure for every person equal enjoyment of rights prescribed by law, irrespective of any ground. Today, any form of discrimination, being direct, indirect, or multiple, is prohibited in Georgia. The law vests in the Public Defender's Office the authority to monitor its implementation. The government of Georgia continued its reforms to build institutional safeguards of independence of judiciary from any outside interference and increase public trust in them. The new wave of reform started in November 2012, empowered self-rule of ordinary judges in running the High Council of Justice, as well as provided an avenue for participation of the civil society. Key words of this wave of reform were depoliticization of the High Council of Justice, where today no politician is sitting as a member, and empowering self-governance of judges within the judiciary. The new reconstituted High Council of Justice has already came into existence, and the next phase of the reform addresses the criteria of appointment, promotion, and appraisal of judges, and assignment of cases to the judges. In autumn last year, the second stage of reform was launched, focused on the guarantees of independence and strengthening of individual judges and his or her involvement of the activities of the court. Within this process, the principle of lifetime tenure for judges will be implemented. Criminal justice. To uphold principles of transparency, accountability, and the rule of law in the country, process of reform series of reforms were carried out. In particular, victims' rights were brought in line with European standards, while sweeping reforms of juvenile justice are underway. A separate code for juveniles has already been drafted and will be adopted by Parliament this year. The mechanism of plea bargaining was reformed. Government initiated robust steps in order to overhaul the mechanism and ensure fair and voluntary plea bargaining process with the defendant. In particular, This law enhanced powers of judges in the process of plea bargain and determination of punishments, enhanced role of the victim in the plea bargaining process, and improved transparency of the whole procedure. Another major aspect of the criminal justice reform last year was guaranteeing institutional independence of the prosecution office. Today, the prosecutor's office is independent and carries out professional functions impartially and objectively. As a result of amendments last year, all prosecutorial powers vested previously in the Minister of Justice, who is, as you know, a political figure, were transferred to the main prosecutor of Georgia, and the power of Minister of Justice to interfere in individual cases has been completely abolished. For the time being, the Minister of Justice has the authority only to define general criminal justice policy and issue respective guidelines that are focused on human rights. After the parliamentary election in 2012, the process of depoliticization of police and transformation of the Ministry of Internal Affairs into a community-oriented organization have been among the main priorities of the new government. In October last year, a new law on police was adopted. It was elaborated in close cooperation with European Union, international and local NGOs, and it sets high human rights protection standards to embody the principles of legality, equality, proportionality, and political neutrality. The infrastructure and standards of the temporary detention isolators have been improved. Since November 2012, no single fact of human rights violation has been reported. This significant and unprecedented progress has been achieved in the most problematic directions of the penitentiary system of Georgia in the shortest period of time. Protection of human rights, eradication of all facts of torture and ill-treatment, and the strengthening complaints mechanism stand in the center of the reforms implemented. Overcrowding of the prisons has been effectively addressed. The number of prisoners in Georgia has been reduced by 60% and is being maintained at the same level already for the last 18 months. Access to quality health care for pretrial and convicted inmates has been considerably improved. Electronic health record has been introduced. Access to life-saving treatment of HCV-infected inmates has been ensured. Spread of tuberculosis has been reduced 15 times. Suicide prevention program has been initiated. Comprehensive units to provide care, service, and proper conditions to drug-addicted and disabled inmates has been opened. Mortality among prisoners has been reduced 6 times, and this is a historic achievement. Living conditions for the prisoners has been improved. 3 old institutions has been closed according to the CPT recommendations. 3 new institutions with modern concept have been opened, and 2 more are ahead to be opened. Food standard has been changed and improved according to the national and international standards. Safety standard in the prisons has been improved. Regulations have been updated and legislative gaps addressed. Since the beginning of the current year, the main focus in the penitentiary has been shifted to, first, psychosocial rehabilitation and resocialization of the prisoners. Second, improving mental health care and upgrade standard of rehabilitation and harm reduction for drug addicts in prison. Third, functional improvement of penitentiary and probation system oriented on specific needs of the vulnerable groups, women, children, and persons with disabilities. In addition, we continued reforming the legal aid service in Georgia in accordance with the UN principles and guidelines on access to legal aid in criminal justice systems, and reconstituted the legal aid service as an independent body. You remember that this was before a part of the penitentiary system, which is not anymore. In May 2012, the law on personal data protection entered into force. The law lays down fundamental principles and guarantees of data protection in line with international and European standards. Within the institutional setup, the Data Protection Supervisory Authority, the Personal Data Protection Inspector of Georgia, was recruited by competition and nominated by the Prime Minister of Georgia in July last year. The inspector is primarily mandated to inspect the lawfulness of the processing of data in public, but also private institutions, receive and consider applications of individuals, conduct awareness-raising campaign, etc. This year and next year, we are starting with a very strong political will the process of strengthening this institution. In the light of this, a decision was taken to define the supervisory authority and expand the inspector's mandate towards data processing for police and law enforcement purposes. During this reporting period, Georgia undertook the commitment to ensure human rights protection by ratifying or acceding to various international regional conventions. In December 2013, Parliament of Georgia ratified UN Convention on the Rights of People with Disabilities in order to progressively realize the rights of people with disabilities according to requirements of the Convention. Government-approved National Action Plan of Equal Opportunities of Persons with Disabilities for 2 next years. The document defines concrete actions, responsible agencies, terms and indicators to reach the goals defined. In April this year, the UN Convention on the Reduction of Statelessness was ratified by the Parliament of Georgia. In this context, the Parliament adopted the package of laws regulating migration policy in line with international standards, and among them implementing the Convention on the Reduction of Statelessness. Government of Georgia pays particular attention to elimination of domestic violence. That's why in June 2014, Georgia became the member state of the Council of Europe Convention and signed the Istanbul Convention on Preventing and Combating Violence Against Women and Domestic Violence, which will enter into force in August this year. One of the main concerns of the Georgian authorities remain with the human rights situation on the occupied territories. In meeting human rights obligation in those territories of Georgia, our government is faced with major challenges. With the installation of barbed wire fences along the occupation line, heavy restrictions on the freedom of movement have been imposed even on the most vulnerable population, especially in need of urgent medical assistance and expectant mothers. Unfortunately, such actions carry a heavy toll. 4 women, including 1 pregnant woman, have died en route to hospital after being refused passage through the occupation line. Despite the numerous calls of international community, up to 500,000 internally displaced persons and refugees continue to be deprived of their fundamental right to safe and dignified return. In these regions that are under Russia's effective control and military presence, the remaining ethnic Georgian population, such as those in the Gali district, lives under constant threat of harassment. Kidnappings, physical abuse, and crimes against ethnic Georgian residents often take place. The government of Georgia spares no effort to cater for the needs of people on both sides of the occupation line. Under the engagement strategy, the Georgian government provides ambulance cars and free-of-charge medical treatment for any patients from the occupied regions, including for women, while with the help of international organizations, the government provides medicines and vaccines for the residents of Abkhazia region. Through the Special Interagency Commission set up in October last year, the Georgian government undertook intensified efforts to assist, together with the UN agencies and the donor community, with the basic needs of the population who live close to the barbed wires. First and foremost, the human rights situation in the occupied regions has to be brought within the reach of international human rights mechanisms. In particular, we support and encourage Office of the High Commissioner for Human Rights to continue efforts to have access to Abkhazia and Tskhinvali region of Georgia. We remain hopeful that the international community will adequately react to the illegal activities in the occupied regions of Georgia, and the ongoing violations of human rights will stop. The anti-discrimination law is the most important but not the only instrument in protecting minorities, including ethnic and religious minorities. As part of the new systemic approach to the minorities, in May this year, Prime Minister of Georgia created a special religious agency to fund other religious confessions beside the Orthodox Church of Georgia, and to work on the issues such as property rights and education in religious communities. Elaboration and effective implementation of a state policy towards integration of ethnic minorities is an important priority for the country. This policy aims at protecting the rights of national minorities, providing their full-fledged integration into our society, as well as supporting further development of a tolerant environment. Since 2009, the state policy towards ethnic national minorities is implemented through the National Concept on Tolerance and Civil Integration and Respective Action Plan for 2009-2014. The Office of the State Minister of Georgia for Reconciliation and Civil Equality, present here, coordinates the process of elaboration and implementation of a policy in regard to ethnic and national minorities. The main aim of the Tolerance and National Integration Strategy is to support the creation of a democratic, consolidated civil society based on common values, which considers diversity at the source of its strength and provides every citizen with the opportunity to maintain and develop their own identity. In concluding my opening statement, let me reiterate that we are open to have, with my very representative delegation, to have engaging discussions with you, with every member of the committee, in those 2 days on all and every issue of your interest. Thank you very much.
Thank you very much, Ms. Tzulukiani. And it is indeed a very impressive delegation, both in terms of authority and scope and range of competence. And I'm sure it's going to be able to provide all the information we could possibly require. So from this moment on, thank you. I go straight to the colleagues who are going to be posing questions in response to the replies to the list of issues. And the first speaker on my list is Mr. Kalin. Mr. Kalin, you have the floor.
Thank you, Chair. Let me very warmly welcome the distinguished and very high-level delegation from Georgia. It's a particular pleasure for me personally to welcome you in light of the fact that in a previous capacity, in my former capacity as representative of the UN Secretary General on the human rights of internally displaced persons, I had an opportunity to visit your country on official mission regularly between 2005 and 2010. Let me also say how much we enjoy having Mr. Varzelashvili among our membership of this committee. We very much appreciate his excellent contributions to the work of the committee. Let me also thank you for a good report that provides detailed information on follow-up to the previous recommendations. Let me thank you for a focused report that looks at developments during the reporting period in a practical way, but remains focused. We also would like to thank for the detailed responses to the list of issues that were submitted well in advance. This is not always the case, but it very much facilitates our work. Of course, we will draw our conclusions at the end of this dialogue, but from your introductory remarks, Honourable Minister, it became evident to me that this dialogue takes place at a time when Georgia is undertaking important reforms aimed at strengthening human rights protection in your country. And let me assure you that we acknowledge these efforts, even if in the next few hours members of this committee will have probing questions and make critical comments. And in this sense, I'm very much looking forward to a very constructive dialogue. Today, I will focus on just issues number 1 and number 2. Issue number one asks to provide examples of the application of the covenant by domestic courts, and asks what procedures are in place for the implementation of the committee's views under the optional protocol. I've read in the written reply that on occasion, in fact, reference is made to our covenant, even though, and I fully understand that the European Convention on Human Rights is much more often invoked. I would be interested to know a little bit more in what contexts Georgian courts were referring to our covenant. This is my first question. Second, you mention in your written answer the statute of the Department of State representation before international courts of human rights of the Ministry of Justice of Georgia. And you refer to Article 9, paragraph 2 of the statute, which authorizes the execution supervision unit of the department to elaborate proposals on measures necessary for the implementation of decisions of international human rights bodies, and to present such proposals to the minister. I understand that this provision also covers our views in individual cases under the optional protocol. However, I would like to know what in practice this means and what the limitations of this procedure are in cases where we're dealing with court decisions that, according to domestic law, have entered into force. Because, as you well know, we only can deal with a case after exhaustion of domestic remedies. And I just would like to raise the question whether this is an effective approach to the implementation of our views, because if this unit can make proposals and suggest them to the minister, it still doesn't mean that a court decision by the last instance that has entered into force can be revisited. So if you could explain to us in more detail what in fact the possibilities are to implement views by this committee, then I would be very happy about that. Third aspect of this issue number 1, going a little bit beyond what we asked. Besides courts, independent national human rights institutions are a very important instrument for the actual implementation of human rights obligations. And I think it's fair to say that Georgia has a particularly energetic and competent ombudsman. What I would like to know is about the resources made available to this institution. We have some information that resources provided by the state and its budget are very, very limited, and that the Ombudsman's institution still depends to a large extent on contributions by foreign donors. Could you comment on that? And would you agree with me that a truly independent national human rights institution that can work on a sustainable basis needs to be funded sufficiently and adequately through the state budget? Moving on to issue number 2, on measures taken to enhance protection under the Covenant for the population in Abkhazia, Georgia, and the Skin Valley region, South Ossetia. You referred to that in your introduction remark, and I fully agree that this is one of the biggest challenges for your government. Of course, under the covenant, state parties are obliged to respect and protect the guarantees of the covenant with regard to all individuals within its territory and subject to its jurisdiction, and subject to its de facto jurisdiction in an occupation situation. I share concerns about the present situation, and I welcome the measures taken. You referred to the so-called engagement strategy. You mentioned as an example the provision of medical services for people who live in those occupied territories. I would like to know a little bit more about the practical experiences with the implementation of the engagement strategy. To what extent is it possible to actually implement it under the prevailing circumstances, and what else could be done from your side? In that context, we are, in our list of issues, are also referring to the law on the law of Georgia on occupied territories. We were referring to the issue of humanitarian access. I do understand that humanitarian access can be authorized even through entry points that are not recognized by your government in order to provide people with food, medicines and articles of daily necessity. Again, I would like to know about the practice, if you could tell us a bit about actual experiences, examples where such humanitarian assistance was requested, examples where requests were not authorized, and examples where they were authorized, so we get a more clear picture about the application. In that context, I also would like to take up another issue of that law, and this refers to the implementation of human rights measures to be taken that are within your power and competence. What I'm worried about is Article 8 on illegal authorities. I'm not so much worried about the article as such, but I'm worried about the possible consequence on the enjoyment of human rights that maybe unintentionally, but de facto, this Article 8 can have. Article 8, paragraph 2 of the law of Georgia on occupied territories says that any act by non-authorized authorities established in occupied territories shall be deemed invalid, that such acts do not have any legal consequences. Now I'm asking myself, what is the impact of that on the enjoyment of people living in those territories, for instance, of the right to marry, as guaranteed in Article 23 of the Covenant, or on the right of a child to be registered immediately after birth, as guaranteed by Article 24, paragraph 2 of the Covenant. Because if I'm taking this article and its literal meaning, then each and every marriage concluded in these territories, in your eyes, is invalid. Children are born out of wedlock, and birth registration is again invalid. Of course, I've seen that there is an exception for issuing status-neutral identification cards, but to my knowledge, identification cards that are issued in reality are not status-neutral. So again, the consequence would be that as a consequence of that law, children born in occupied territories are not registered immediately after birth in a legal sense, in the sense that would be recognized. And I very much would appreciate your comments on this, maybe unintended, but still it seems to be relevant negative impacts of the law on the enjoyment of human rights of your citizens. Thank you.
Thank you, Mr. Kalin. And I should make clear that at this stage we're dealing just with issues 1 to 14. We'll have the first round on issues 1 to 14. And then when we've done that round, we'll go on to the rest of the issues under consideration on the list of issues. So the next speaker on my list is Mr. Fatala. Mr. Fatala, you have the floor, sir.
Thank you very much, Mr. Chairman, and I would like to welcome the delegation of Georgia with a very large number, and particularly the women's representation in this delegation, which makes it a little bit unbalanced for men. But anyhow, I will go, and my questions are related mainly. I will begin with question number 3, which is related to non-discrimination. I have noticed with satisfaction that on the 2nd of May 2014, as it has been stated by the minister now, that the Parliament of Georgia has adopted the Georgian law on elimination of all forms of discrimination. After a long debate with NGOs and other concerned experts, but I have a number of questions and clarification which I would need to address with the delegation. First of all, when we examine the draft law, not the adopted law, I have noticed that that there have been a monitoring system through the Inspector for Equality Protection, and this was an independent inspector doing this issue of monitoring. Now, the new law adopted does not anymore refer to the Inspector for Equality Protection, but it gives the task of monitoring to the Public Defender's Office to monitor the implementation of the law. In this regard, I would like to know how the public defender would be in a position to monitor the law. And also, I understand that the public defender has no power to apply to the court and request the imposition of administrative penalty. And this was previously, administrative penalty was in the draft law, which is not reflected in the adopted law, as I understand. And also the resources which are allocated to the Office of the Public Defender in order to be able to undertake this very difficult task. In relation to the issue also to this issue, I would like to raise the issue of the effective remedies. In the draft law, we had a procedure to have effective remedies in administrative proceedings. I would like to know if this is still the case, because I understand from some reports that the Ombudsman is undertaking this task now, and then the Ombudsman is not taking decision but just making recommendations in this on this issue, and also that the Ombudsman Office lack of financial resources. Also, I would like to know what about the effective remedies of judicial proceedings, because nothing has been referred to about the remedies when we follow judicial proceeding in the draft law, and I'm not sure that this has been reflected in the adopted law on the 2nd of May. In addition to this issue, I would like also to raise the issue of the ability of the government to avail sufficient resources to facilitate coherent enforcement of this law. And some doubts were raised concerning the lack of clarity on the type of measures that can be implemented against offenders, and whether these will be sufficiently stringent to discourage and prevent manifestations of discrimination. Please clarify. Now I turn to issue or question number 4, related to the criminal code. Your government provided in paragraph 20 of your reply to the list of issue an overall reply to all issues addressed in question 4. Such reply did not address the following points. First of all, does or how your criminal code address the issue of incitement to racial discrimination? Please explain. Also, no reply has been given to whether the Georgian law allows the ban of racist organizations, a point the committee raised in question number 4 about the organization and the ban of racist organization. Also, in your reply did not provide the committee with the measures taken to combat speech and use of discriminatory language against ethnic, religious, or other minorities, including in political discourse and the media. The issue here really, or the emphasis, is the need to cover the latter issue of political discourse and the media when it relates to hate speech. Please clarify this issue. I turn now to question 6 regarding persons with disability. Paragraph 18 of your reply to the list of issues provides the committee with a general reply on this issue. I will appreciate receiving detailed information on how the law on elimination of all forms of racial discrimination addresses the issue of appropriate health care, education, employment, and social assistance to persons with disability, as well as their de facto accessibility in public places and transportation. Now I will address also the issues related to question number 13. This question compromises 2 elements. The first is related to the ill treatment of prisoners at, excuse my pronunciation, Gladny prison and Ksani prison number 15 and prison 2 in Kutaisi. Your written reply in paragraph 70, 71 and 72 does not provide answer on the sanctions imposed on perpetrators and on the remedies provided to victims. Please provide us with such information. The second element of question 13 is related to practical steps taken by Georgia in a number of issues. A reply was provided concerning practical steps related to guaranteeing the right of prisoners to submit complaints. It was very clear that this is guaranteed in your practical steps, but no reply was provided in relation to the following elements. The first one, steps to ensure the adequate protection of prisoners against reprisals. The second, measures taken to ensure de facto access of victims to compensation, including relevant statistics about compensation given to victims. And the third point, the committee takes note of the rehabilitation programs provided to prisoners, but no clear answer in your reply is addressing the availability of functional state-owned rehabilitation programs for prisoners who are victims of torture. Here it's very precise, rehabilitation programs for prisoners who are victims of torture. Please provide the committee with replies to all these 3 elements. And I thank you very much, Mr. Chairman and Madam Minister.
Thank you very much, Mr. Fatala. The next speaker on my list is Mr. Zlatescu. Mr. Zlatescu, you have the floor, sir.
Thank you very much. On number 5, gender equality, The adoption of a gender equality law in March 2010 has helped the cause of gender equality in Georgia. Indeed, the progress made has been significant, and I acknowledge, yes, the progress as expressed in your original statement. Women's rights activists have advanced the initiative of introducing mechanisms that would generate a more balanced outcome in the legislation on political parties and the electoral code. How is Georgia going to address from now on the issue of women's underrepresentation in politics? Women are often employed in unwaged or poorly paid jobs, and the labor code leaves room for significant improvements in regard to women. What's more, there is no national strategy for promoting and supporting women in the labor market or giving them adequate chances to prevent poverty and marginalization and engage in the formal economy. New NGO reports reveal that while encountered disadvantages in finding employment in other spheres, women are particularly well represented in the civil society sector, which is encouraging. Women comprise 58% of NGO staff in Tbilisi and 63% of the NGO staff in the regions of the country. How is Georgia compensating or willing to militate for the reduction of the effective gap between genders when it comes to employment, work conditions, and professional training? What are the future initiatives and social programs that address the gender economic inequality? Abortion seems to be the major birth control method in Georgia, in spite of the fact that during the last years the promotion of various family planning methods have had a positive, visible result on the health of women. However, many women still do not have key information or even access to resources about reproductive health services. How is Georgia going to promote access to its family planning policies in marginal and rural areas in the near future? The two ethnic conflicts have generated an important number of internally displaced persons, IDP. The recent 2009-2012 strategy on IDPs has positive gender aspects, but IDP women and particularly rural residents are still finding themselves in most vulnerable conditions, generating marginality and poverty. Georgia, as we know, hosts many ethnic minorities. Ethnic minorities women are often subjected to cultural and language constraints, breaches of human rights which result in low access to information and skills, which we agree can delay their integration and development. How is Georgia going to help in the future the integration of its ethnic minority women and pay attention to sensitive factors such as cultural and linguistic differences? On number 7, other minority groups of women, particularly sexual minorities, are still marginalized in today's Georgia. Indeed, LGBT movement activists have decided to associate with a few women's NGOs, but due to lack of proper legislation and having to face the typical mentality biases of a patriarchal society, I'm Romanian and Romania has experienced similar transitions. They are to face all derisive attitudes from public contempt to social isolation and discrimination. How are you planning to address this in a future legislation pack that would prevent LGBT women from being marginalized and misrepresented? Thank you very much.
Thank you very much, Mr. Zlatescu. The next, el próximo orador en mi lista.
The next speaker on my list is Mr. Salvioli. Mr. Salvioli, you have the floor. Thank you very much, Chairman. I would like to echo my colleagues in extending a very warm welcome to this impressive high-caliber, large delegation from the State Party. I would like to raise some questions relating to issues 8, 9, 10 and 11 of the list of issues that we submitted to the State Party. Question 8, which refers to investigation of cases of sexual and gender-based violence, particularly rape committed during the 2008 conflict, and the outcomes of the various prosecutions and remedies to victims. We have yet to receive, or not received, a reply from the State Party on this question, and therefore I am obliged to ask this question again and encourage the state to seek to provide a reply to this question. I mention this because in paragraph 54 of the state party's reply, the state indicates that only one case out of the large amount of material investigated could be deemed to be connected with a sexual crime in the framework of armed conflict. I am deeply concerned by this, Chairman, because we have information, voluminous information from NGOs and bodies such as UNIFEM and other United Nations system organizations that indicate that there is a shocking number of acts of a sexual nature of this type, sexual violence committed in the course of the 2008 armed conflict. And I would like to ask this state what is being done in terms of the investigation and what failings they believe there are that have led to the failure to pinpoint these crimes and bring the perpetrators to justice. Chairman, we all are aware that in the course of armed conflict there may be rapes, sexual violence committed particularly against members of vulnerable populations, including women, and I cannot believe that investigations have failed to turn up such cases. With regard to paragraph 9, which makes reference to measures taken to combat violence against women, including domestic violence, I would like to thank the state for the information it supplies. Here, conversely, the state has provided a great deal of information, and this speaks to a large number of measures, the adoption of the law to establish the crime of domestic violence in the statutes, and I think the committee ought to commend the adoption of this law. However, information from NGOs indicates that there are still large numbers of domestic violence cases, physical, sexual and psychological violence being perpetrated within the country. The NGO coalition has also told us that the way in which cases of domestic violence are investigated and dealt with is not the most effective within the state. Moreover, there is a limited number of shelters and services to assist women who are victims. In paragraphs 32 and 33 of the replies, we're told by the state that domestic violence has been qualified as an offence, but this is always in the context of physical suffering, and I would like to ask the state whether it is also intending to describe psychological violence in the statutes. Often domestic violence takes this form. I would like further clarification as to whether conjugal rape is prohibited. This is very important for us, and if spousal rape is typified, I would be very interested to hear about investigation and sanctions handed down for spousal rape. This is a problem that we bring up with states typically in the course of this interactive dialogue. I would also like to know whether there is a specific prohibition on sexual harassment, notably in the workplace, and whether there have been cases that have come to court. In this context, my colleague Mr. Zlatescu asked some questions about abortion. I'm not going to repeat those because they have already been raised by him, but I would like to add a question as to whether the state intends to review the provision pursuant to which a waiting period of 5 days is imposed. It used to be 3 days, it's now 5, before a woman may having decided to voluntarily interrupt her pregnancy may be able to receive an abortion. I ask this chair, given that the World Health Organization and CEDAW, given that the state was being examined in the Committee on the Elimination of all forms of discrimination against women yesterday or the day before yesterday, where this question arose. This is also an issue that comes up under our covenant, and that's why I'm asking it, given that it touches on non-violence against women. I also would like to ask the state what measures it is taking to raise awareness amongst the population about selective abortion. In other words, once it has been determined that the woman is carrying a female fetus. I am deeply concerned about the issue of early marriage or child marriage, and I would like to ask the State Party whether this is prohibited and whether measures are being taken to prohibit this practice, given that the Ombudsman has supplied information regarding a large number of cases between 2011 and 2013 of girls who have dropped out of school primarily as a result of marriage. These were young girls that we are talking about. Reading paragraph 10, with regard to steps taken to investigate violations of human rights in the course of armed conflict in 2008, we are not provided with any further information from the state. I therefore must ask the question again. I would ask the state whether the progress has been made in investigating these cases, whether any trials have taken place, whether there have been convictions handed down or reparations. The information given by the state is general in nature. We lack precise information, and the committee does need to receive this information to enable it to adopt its concluding observations. Lastly, with regard to 11, under the list of issues to the state party, here the state is requested to provide two pieces of information. These relate to the death caused by excessive use of force by police and prison officials in the course of riots in March 2006 in Tbilisi prison number 5. And here the state responds saying, well, I'm concerned that in paragraph 58 we are told that only one person was convicted in light of these events. Clearly there were more people than that involved. Moreover, this conviction was to 3 years and 9 months imprisonment. This seems very little when taken in proportion to the seriousness of the offences that were being tried. Lastly, Chairman, a question was asked to the State Party with regard to excessive use of force by law enforcement officials, and the state replies that these events dating back to 2011 led to the prosecution of the former Minister of the Interior. I would like to know if any other people were prosecuted. I would also add, Chairman, lastly, 2 additional questions. Could the state provide information on the case of Mamuka Miałkastadze, who committed suicide a day after the individual was interrogated by the police in connection with detention relating to alleged drug-related activity connected to the friend of the victim? The complainant makes reference to external lesions, and suicide and external lesions clearly don't quite fit together. This suicide, in inverted commas, took place in prison, and I would request information from the State Party on this case. Lastly, the case of Shalva Tabukashvili, says the speaker, who apologizes for the pronunciation, who is the son of a former chief of the Special Services and was found dead. The father complained that law enforcement officials had abducted this person and subjected him to cruel treatment. These two questions were not in the list of issues, Chairman, and I do appreciate that perhaps the state is not in a position to provide information at this stage. I'm very grateful to this state, and thank you, Chairman, for giving me the time to ask these questions.
Thank you. Gracias a usted, Señor Salvioli. Did I get the impression that the delegation might like to hear those names again? Si puede reiterar.
Could you please repeat the names that you made reference to a moment ago, sir? I will try to pronounce them in the correct way. The first was Mamuka Mikotatse.
Ok. Bien. Y el segundo
The second
es Shalva Tabukashvili. Wow. Necesito un curso de idioma.
I'm afraid I do need some extra language training. Thank you, Chairman.
Second time round was perfect. Okay, thank you. Muchísimas gracias, señor Salvioli. Et le prochain orateur sur ma liste.
The next speaker on my list is Mr. Benasher.
Monsieur le Président, je vais avoir...
Thank you, Chair. I'm going to have the same problems as pronunciation as my colleague, Mr. Savioli. First of all, I would like to welcome and to thank the distinguished delegation of Georgia, who today are in dialogue with the Committee on Human Rights. This is indeed an impressive delegation. Impressive in its professional attitude, and I think this demonstrates indeed that Georgia does attach a great deal of importance to human rights matters. Ladies and gentlemen, I want to look at issue 12 with you. Issue 12 and 13. I'll have others, but I'll bring them up in the second round of questions. Issue 12, as you know, that is the role of the judge in combating torture according to the new Code of Criminal Procedure. And this matter also relates to the late inquiries that were put underway as a result of bad or degrading treatment. There's also Article 333 of the Criminal Code, which is involved abuse of power, instead of Articles 144, which relates to torture and inhuman treatment. So I'll go into that later. And it also relates to a number of torture cases and the inquests, the investigations and condemnations that were prosecutions that were initiated, as well as the remedies granted to the victims. Now, the response that the government of Georgia gave us in the response to the list of issues can be found in paragraph 60, 61, 62, and 63 of your response. Now, very quickly, I'll sum those up. Now, you're saying that in accordance with Article 177 of the Criminal Code, the judge, as from the first hearing, is obliged to inform those involved as to their rights, but in particular, and this is what is of interest to us, they have to inform them of their right to start an action if they were subjected to some kind of acts of torture. So that's up to the judge to do this, is obliged to do that. He's also obliged to act on the basis of this if this is brought up, and this is very important for human rights, the judge has to inform the person involved that he is not bound by his original statements, that is, before the case was actually heard in court. Now, when it comes to Article 333 and Articles 144, you tell us that, in fact, everything depends on the specific circumstances of each case, and that if any inhuman treatment is undertaken in order to obtain confessions, it's Article 144 that applies. Now, when it comes to statistics, the country has given us in paragraph 62 and 63 of their responses. They've told us about some of the prosecutions that have taken place. It seems to me that the explanations are precise, and they also break down the prosecutions initiated depending on whether they are based on Article 333 or on Article 144. At any rate, there have been prosecutions that have taken place, convictions of those who were guilty of such ill treatment, and the sentences range from 6 months to 7 years of imprisonment. And there are even 2 directors of prisons that were affected by measures, by such sentencing. And finally, the government tells us that the victims have, of course, a right to remedies. The data that you have provided us with, in any case, is confirmed by the report which was put to the Human Rights Committee by the public defender. And in his report, which is an excellent one as I see it, it has gone through the list of issues in the order that they were provided by the committee. So I will look in particular at the comments that were made by the public defender. In fact, in the report that he has submitted to us, and which is a public report, it goes without saying, the public defender has laid stress on the lack of correlation of using Article 144 of the Criminal Code in order to sanction the crime of torture. And the explanation that is given by the public defender is as follows. It is that this practice and is the result of a plea bargaining agreement. That's an agreement that exists. So this is an agreement that takes place between the judge and the accused in order to strengthen, to a certain extent, the application of the amnesty law, which was adopted in December 2012 by Georgia. And it is this plea bargaining agreement which means that the sanctions against those who are responsible for ill treatment and torture are not adequate. They're too weak as opposed to the seriousness of the crime. And the public defender suggests the following. He suggests that it is prohibited to have plea agreements, in particular for anything relating to torture and ill treatment. He suggests, and I'm sure the country is aware of this, since, of course, you have read this report, so the prohibition of these kind of agreements when it comes to acts of torture. And my question is, what follow-up was given by the government of Georgia to this proposal, which I think is an extremely reasonable one? And it does go towards protecting human rights, which affects, of course, an authority in Georgia. There's a public defender. So what follow-up was given to this proposal? Now, issue 13. So here we're talking about providing information on the investigations on the number of prisons in which there were alleged ill treatment, acts of violence, and some of my colleagues have already mentioned this problem. So these are acts of violence against prisoners, and one of them even was videoed. And the response that we have on this is the response 70 to the list of issues. Now, you say that an investigation was initiated by the Chief Prosecutor's Office. So there was an investigation that took place, and you tell us as well that as a result of this, there was a strengthening of administration of controls in prisons, in particular the general inspectors, the investigation department, which is subject to the Ministry of Corrections. I'm not quite sure how that sounds in French, of Georgia. And also a strengthening of the internal monitoring unit of the prisons department. So these reforms, these administrative reforms, have as its aim to give great independence, greater powers in the case of acts of torture, and that is why these various administrations were directly related to attached to the ministry. So the prosecutions meant that 43 officials, according to the 80 officials from the prisons were sentenced and prosecuted. So it does mean that the phenomenon does exist. So you also tell us that a complaints office was opened for the benefit of the prisoners, and that a preventive mechanism was also implemented. In particular, the role of the public defender of Georgia. So among the arguments that you also bring up is that the NGOs were involved in this work to consolidate controls on the way that prisons function. So to conclude the presentation of your arguments, and I take the information that you give us in the fourth periodic report. I've come back to the fourth periodic report, in particular in paragraphs 23 to 28 of your periodic report, where you inform us that Georgia has set up two institutions which I think is useful for prison control. The first is the Interinstitutional Coordination Council, which was set up in 2007. This is in paragraph 26 of the periodic report, and a special prevention group, which can be found within the Office of the Public Defender himself. So here, objectively, we have to praise the government of Georgia for the very laudable efforts that they have undertaken here. But nevertheless, there are a number of points that are not totally clear. The first one, and that's a question I would like to put to you, whether all the disciplinary measures that were undertaken against those responsible, the responsible authorities in the prison, are they all related to ill treatment and torture, or do they relate to other problems, such as corruption issues or others? And I would also like to say the following, that in spite of the efforts of the government, in spite of the efforts made, there are nevertheless gaps here. And in order to overcome those gaps, the public defender has suggested setting up a special group in order to control and investigate acts of torture. Now, special group, what do we mean by special group? It's an independent group that is not part of the official inspections of the state authorities, and that is suggested that they should control the functioning of prisons. And that's in page 7 of the report that was given to us. And I'm just would like to ask whether this proposal, which I think is a reasonable, just one, is this proposal taken into consideration by the government of Georgia? So I'm asking this question in the light of recent events, they're rare, of course, but they do exist, which proves that Georgia doesn't have any structural problem with torture. It's not systematic torture that takes place, but there are individual cases. And Mr. Salvioli, my colleague, has given us an overview just now. And indeed, in July of 2013, we were told that there was the Mamuka Kantatse business. And in December 2013, there was Vanu Merabishvili. And that's in December 2013. And in March 2014, there was a case of, which Mr. Salvioli also mentioned, Shalva Taltukashvili. And these are very doubtful cases. I would like to hear your opinion on those cases. Are these genuine cases that have been established with proof, etc., or are these cases that are very doubtful, in fact? But they were brought up, there were signals, and they were brought up in the information that we have received. I would like to hear the opinion of the delegation on those 3 cases of ill treatment. Thank you, Chair.
Merci à vous.
Thank you very much. Mr. Benachur.
Pleasure in giving the floor to Ms. Vartafal. You have the floor, ma'am.
Thank you, Mr. Chair. Let me also join my colleagues in warmly welcoming this distinguished and high-level delegation. For now, I'm going to focus on issue number 14. In your reply to the list of issues, the State Party makes no reference to corporal punishment, nor to any measures aimed specifically at eradicating violence, punishment of children in the home or any other setting. As in the State Party's periodic report, measures addressing domestic violence are described, but the near universal acceptance for a degree of violence in childbearing, together with deeply held views that parents and other adults have a right to physically punish children, mean that corporal punishment is not readily perceived as domestic violence. In the committee's view, all violence, including when inflicted in the guise of discipline or correction, is prohibited. And in this context, I will reiterate the question. Please report on measures taken to ensure that corporal punishment has been eradicated in all settings, including the home. And I thank the delegation in advance for their answers. And with that, Mr. Chair, I thank you.
Thank you, Ms. Vattarfall. That exhausts the list I already had. Is any other colleague wishing to come in on issues 1 to 14? If not, then we come to the point at which we're going to suspend the meeting for 15 minutes or so to allow the delegation to concert to organize how it's going to deliver its answers and distribute its responsibility for providing answers. We'll meet again then at, let's be flexible, 20 to 5. We'll meet at 20 to 5 to hear the beginnings, to hear the delegation's answers before we carry on with further questions. So with that, I suspend the meeting. The meeting is suspended.
ეხა ჯარისკაცები ვით სწრაფად წავედით.